Welcome to J is for Justice podcast. If live breaking news and following true crime is your thing, then please consider subscribing to my channel. And if you like what you see in my videos, please consider giving them a thumbs up. Welcome back. Welcome back to J is for Justice. We have got the Kohberger hearing. I'm going to give a couple minutes to get some people in here, and then I will start the footage. Come on, come on. Everybody get comfortable. Get your snacks. Get ready. Because we are going to roll this footage. Hello, Michelle. Welcome, welcome. We are live on YouTube and on Facebook. Yay, Casey got her notification. All right, guys, we've got the Bryan Kohberger hearing from today. This was just uploaded to us. What's up, everybody? What's up? Yay! I love the people that finally made it to a live. That's awesome. All right, we are going to roll let's get this up on the screen. We've got the Bryan Kohberger hearing as promised. As promised, I would never let you guys down. Never let you guys down. Not if I can help it anyways. So if you could hit that like for me to thank me, that would be great. That's all I ask. Hit that like button. Hit it good and hit it hard, folks. Are we ready? Are we ready to roll this beautiful bean footage? All right, here we go, guys. Welcome to J is for Justice. Thanks for being here.
All right, let's get on the record, please. Thank you. We are now on the
just because they didn't recognize.
be okay. All right, let's get on the record, please. Thank you. We are now on the record. This is the State of Idaho versus Bryan Kohberger. Got an echo there still. Case number CR 2922-2805. You have that adjusted properly? Okay, great. Couple of things I just want to share. Number one, I apologize for the delay. We were supposed to start at 1 o'clock. The hearing that started at 9:30 went a little long, but it was important. You're probably wondering why it was sealed compared to this part of the hearing, and that is because we were dealing with the procedure of the grand jury, the procedures of the grand jury, and in a lot of details. And the grand jury is secret, so that's why it's sealed. And whether you like it or not, it's baked into our United States Constitution and the Idaho Constitution. So there's a reason for that. I advised camera people not to turn on the cameras until I was on the record, and they turn off when the record is off. I just want to remind you, you just heard Matt talk to you about not having your phones, your laptops to film anything, to record anything. That would be a violation of the rules. And we will take away your laptop or your phone. Some of these rules have been violated in some of our hearings, and I have an obligation to put a stop to that. And I'm sure you're probably interested in this. I haven't put a decision out yet, but what I'm going to do is take control of the cameras in the courtroom. I'm not going to ban cameras in the courtroom, but I need to have more control over what the cameras are doing and what media or people who are not media are doing with the filming. I know I can only control so much, and that's why I continue to urge people to be patient and have some dignity and some restraint. And some of that I've heard or seen has been disappointing. Just so you know, yesterday I issued an order addressing IgG DNA, and there's going to be an order for in-camera review that I'm going to go through. In-camera does not mean anything about a camera. That just means I look at the information before I can share it with the defense. Let me see, what else did I want to kind of share with everybody? I think that's about it. So, we're here now on the defense motion to dismiss indictment on grounds of error in grand jury instructions or in the alternative remand for preliminary hearing. So Mr. Logston, I believe, is going to present the argument. Thank you.
Thank you, Your Honor. Well, as Your Honor is aware, I wrote a lengthy brief or two on the subject of where we're supposed to be legally with our grand juries and where we actually are. And as Your Honor let me know this morning, probably not going to change your mind because the Idaho Supreme Court has, I think the court thinks, gone the other way. So, I guess I would accept that kind of ruling as long as the court agrees with everything else I have to say.
Oh, well,
But
I don't know about that.
assuming that you don't, let's, I guess, just kind of walk through the simple steps here. So, at issue in this particular case is Idaho Code 19-1107, and the infamous language in it that says that grand jury ought to find indictments when all evidence before them taken together, if unexplained or contradicted, would in their judgment warrant a conviction by a trial. And the first question that a court has to ask is, what does that mean? you start with the plain language, which we argue what warrants a finding or a conviction by a trial jury is beyond a reasonable doubt. And it meant that back in 1887, when the territory took all of these statutes, almost entirely from the state of California, and it means it today. And then we also pointed out that the great state of California, when they had these on their books from back in the 50s, had already a case in 1962 where they said that it's clearly something more than probable cause, but they weren't too specific about exactly what it meant. And the state has pointed out that if you look at really old dictionaries, it looks like the word warrant means what you might think it does to old-timey folks, as it does to us, that if it warrants doing something, it means that it would permit doing something. So the plain language seems to support what we're saying. And the biggest problem that I have then is just that obviously everyone in the country disagrees with me, from sea to shining sea, and so I'm now put in a position of trying to explain why that occurred and why in the year of our Lord 2023 we are suddenly finding out that that's not quite how things are supposed to be. Why did we forget that we passed all these laws? And I don't have a great answer for that, other than I think the only time I ever heard about the field codes before I was looking into this was like a really short moment in a class that I took back in law school. So, I mean, it's somewhat famously kind of the first attempt to codify the law of the day. It takes place in New York and spreads across the country back in 1850. And I think what I read in the tea leaves from the New York decisions and the later California decisions is that there was pushback at some of the things that the field code was trying to do. And one of the things that the field code very openly said it was trying to do was fix the grand jury system. Because the grand jury system was believed to be essentially broken. For a lot of the same reasons we don't seem to like grand juries very much today. It was essentially believed that grand juries were hard to control. Grand juries would essentially always favor whatever it is that they were told and would always indict the accused. And so as a system to protect people, it didn't seem very protective. And they pointed out in the field code, if you go back and read it, that essentially the secrecy aspect of the grand jury is both its most powerful sword and its kind of its worst aspect at the same time. Because you just don't know what you're going to get out of it. And so they create a bunch of statutes that start to rein in what grand juries can and can't do. And they create some scenarios under which grand juries can be reviewed. And they, in the New York, they call it their Court of Appeals, but it's their Supreme Court, says, even though we have these statutes that say we should only set aside these indictments into these particular moments, clearly there's got to be some sort of a due process protection. If you're going to pass a bunch of statutes that rein in a grand jury, and if you can show that somebody's not following those to the prejudice of the accused, then that's going to work for dismissal as well. And that doesn't seem to be very controversial. We see similar language in that Gaspar case that we talked about in the state of Idaho, which I think dates to like 1913 or something along those lines. But at the same time, while the state of New York is trying to figure out ways to not have to abide by the language of what would warrant a conviction by essentially saying, if you can tell the grand jury that is their burden, but you can also tell them the probable cause thing. As long as they hear both of it, it doesn't really matter. And then the state of Idaho says, well, that's not even what that means, without any additional explanation for what they're talking about. And California apparently just kind of forgets about it until sometime after they've already passed a law in the 40s that says you can only dismiss a grand jury indictment if you can show that there wasn't probable cause. That kind of moots the whole situation because they've obviously fixed it by statute. Our situation is such that we have this thing on the books, and the only group that seems to really dislike it is our Supreme Court, who keep having these opinions where they're like, please, prosecutors, stop telling people it's beyond reasonable doubt. This happens in the early 1900s, and it continues until the 80s, and they finally say, look, we passed a rule. I hope it's clear now. Stop saying that your burden is beyond a reasonable doubt. Well, as the court knows, the way that those rules get created is a bunch of people that get invited to parties, unlike me, in the legal community go and are selected to sit in a room, decide what those rules should say. And there's quite a bit of the time it seems like the Supreme Court will later have an opinion and go, this is weird, why is this one of our rules? And so to simply say that, well, because the Supreme Court wrote it, that's their opinion on the matter isn't quite accurate. But clearly the Edmonton court was behind that as a concept. At the same time, nobody was arguing with them about it. Nobody argued about it, the issue, until just now. Well, that's not quite accurate. Obviously, Mr. Anosco raised this in a few district court cases up in Green County. But nobody's really been digging into this or raising it until this time. So when the court says, look, the Supreme Court's already got a rule on this, Supreme Court's already ruled on it, it's just not true. They have never ruled that probable cause is the basis because there was an argument about it, and they said, no, you're wrong, that's probable cause. That hasn't occurred. They ruled a lot of things, but that's not one of the ones. And the fact that they adopted a rule that says something that they believed doesn't necessarily set in stone what the law is, or for that matter, what the Constitution has to say about it. So the big issue, I think, at least my favorite issue here, was can the Idaho Supreme Court override the legislature and lower the burden of proof for the jury? And that was a tricky one because we don't really have a case that just comes out and says that the burden, or for that matter, I guess I don't know, we got this all kind of mixed up when we were doing the arguing. So the burden of proof, I think we decided was actually who has to show something, and then it was the standard of proof is the amount that has to be shown. But everybody confuses it all the time, and I'm confusing it right now as well. But I'll call it the standard of proof just to be less confusing. In any case, the standard of proof is that something that the judiciary has power over? In other words, is that simply a procedural rule, or is it a substantive rule of law that courts can't mess around with? And we argued, it cannot be that if the Supreme Court woke up tomorrow and declared that the standard of proof in our cases was something beyond reasonable doubt in trial cases, that we would also say, oh, well, that's what the courts get to do. Because if you read those cases, what they talk about is that that is a right, a due process right, essentially, of the accused that is set by the Constitution, right? That's what In re Winship is about. It set the standard via the Constitution, locking in the standard of proof that's required for a conviction. And so when we talk about these standards of proof, it is true, obviously, that if you look through the case law, you'll see courts setting a standard of proof for their own evidentiary rules. But you don't see it in many other places. What you see them doing instead is having somebody come in and say, well, the legislature set this standard of proof, but we think you should make it higher or lower based on, and almost nobody ever says lower, it's always higher. And we're always arguing that the Constitution clearly must set it in at some higher point to protect people, and then the courts lean in and say, well, we don't see any particular reason why the legislature messed this up, or if you're in the United States Supreme Court, occasionally you say, well, we do think that this is goofy and we're going to raise it. Okay? I couldn't find a case where the Supreme Court or anybody else leaned in and said, we think that the legislature is being a little too protective of its people here, and we're going to move down the standard of proof for the government in this particular case, or one party versus the other. Typically, in this country, we try to protect the accused, and we believe that those protections are given to us via the Constitution, and via these concepts of due process that come to us with common law, which is where this gets so messy, because the common law would tell you that it's probable cause, and it's some guy named Field in New York who's telling you that it should be something else. Well, we could get into all of that, but it would be, I think, more philosophical than anything else, because the state of Idaho didn't do it that way. The state of Idaho, as a territory, adopts a bunch of codes out of California, a code that they've already looked at, a code that they've already said, these words clearly mean something more than probable cause. This is what you're adopting. If you come and get it, the state of Idaho goes and gets it and adopts it. So that's what the state of Idaho is adopting. I obviously recognize that the founders that wrote the Constitution did not appear to recognize what was already on the books in this regard. However, just because they didn't recognize that doesn't mean it's not still part and parcel of what was thought to be true by a large portion of the citizenry of Idaho, who are the actual ones who ratified the document. The only thing we know is that from 1890 to Edmondson, the Supreme Court of Idaho was repeatedly admonishing prosecutors to stop using a beyond a reasonable doubt standard for a grand jury. And that, it seems to me, is pointing to this concept. I think we're going to talk about common practice. The common practice looks to have been that everybody thought that the standard for the grand jury was beyond a reasonable doubt. And I don't think this is like worthy of the parade of nightmares that I've been reading about. Obviously, in each one of those cases, the prosecutor was able to pull it off. And little wonder. I mean, it's still a grand jury proceeding. It's still just the prosecutor in a room with 16 citizens, 12 of which have to agree. They get control over basically everything that's being put on. I mean, the guardrails being put in, hey, let's use admissible evidence. Hey, let's not pull in hearsay witnesses. That kind of thing is not going to somehow make this impossible and make it so that it can't possibly work. What it's intended to do is just make it so that if you're in a position to get an indictment against somebody, you're going to put on your A game. But obviously, we've been talking a bit about how we don't think that that's what occurred in this particular case. And we certainly don't think that if the court were to adopt this in this particular case, that this would even remotely cut the mustard, because we know from the grand jurors that at least 6 of them wanted to hear more until they were essentially cut off and told probable cause is the standard and what are you people doing?
You probably should cut that, what the grand jurors did or didn't do.
Fair enough, good. But I'm just pointing out that there's clearly prejudice in the record that the court can see from what they were being instructed. It's also, as we argued, clearly going to be fundamental error. You tell the grand jury that this is the standard and it's actually something else. You can't possibly think that the result that you're getting is the accurate one, and so you have to do it again. I mean, these are fundamental rights that people have, and so clearly that would be the way to go.
Right, but you just agreed that the court and the case law, going back to at least Edmondson, have the standard as probable cause. So, to just say, well, they were given the wrong instruction is not exactly the case. I mean, that is the standard that has been used in Idaho for years, maybe 100 years. It was different. It was different there for a period of time, but after Edmondson, I thought that it was pretty much settled. Now, I understand the argument between substantive and procedural, and that can be a legitimate argument, but I'm not sure it's fair to just say, well, they were given the wrong instructions if everybody's using that instruction throughout the state.
Well, Your Honor, if that were true, then I'm not really sure what I'm doing with my life, because I've spent much of it arguing that things that everyone in the state is doing are just wrong.
True.
And occasionally, rarely, but occasionally, somebody says, no, that guy's right, and my client walks out of prison. So,
Well, that's fine. You can make an argument that something should change, but are you telling me that other places in the state are giving a different instruction, that it should be beyond a reasonable doubt?
What I'm telling you, Court, is that it appears that up until 1980, that was true. And so the Supreme Court enters its rule, sort of has this ruling that talks about that, but nobody's arguing with them about it because they don't have access to the internet, and nobody has a copy of the field code or what California was up to.
Well, Justin Weisslein argued about it in a dissent in Edmondson.
And we thank him for it, although...
Okay, but
If
you
you
can't
go
say
back-
that there hasn't been an argument about it.
Well. No. If you go back and you read what Justice Weisslein did, Justice Weisslein didn't know about the field code. He knew it came out of California. He knew that it meant something different.
I think it's attached on the dissent.
That's
Some of that.
No,
Oh,
California.
those are earlier. Oh, that's the earlier session.
He has the California code, and he has the stuff on the territories. That's what he's got. But he doesn't know. If you read the field code, which apparently nobody did, except, Justice Field in California, if you read it, it literally tells you what it's trying to do. It spells it right out. And you can find it for free on Google Books, which is where I got it. I don't have a copy. I'm not even sure where you find it, but except for Google Books. You can find this thing, and they have a whole preamble to how they're trying to save the concept of the grand jury. They want it to be better than what it is. They understand people have concerns about it. Let's make it better. And it gets adopted in California, and then we took it from that. And then that's what I think should matter. And the fact that the plain language of the statute is being read by every prosecutor in the state up until the 80s when the Supreme Court finally gets them to stop, because the statute's relatively clear. And so the only person who's pushing back against this are these Idaho Supreme Court justices who don't like it. But there's nobody coming to them and saying, here's a copy of the field code, this is where this all comes from, this was the point. Instead, there's just this concern that who could possibly want such a thing? How would we be safe if our communities are only able to indict people beyond a reasonable doubt? It's just too much. It's too high a stake. That's hard to believe, given how many of these cases are making it up, because they were convicted. There's no reports anywhere that I was able to find that in the state of Idaho, all these prosecutors were mistakenly using beyond a reasonable doubt. There's just no indictments going on. Nobody was going to prison. Nobody was getting the death penalty. It was a free-for-all, and we had, posses riding around and having to deliver justice because the standard was too high at the grand jury proceeding. But that's not what was occurring. What you had was a perfectly well-running system that you had Supreme Court justices that were not aware of where this stuff was going. If somebody had come to them and said it, we'd have a ruling on it. But nobody did. And in fact, we don't have really any state that's ever done the heavy work of this. You've got the New York Court of Appeals is about the only one that was aware because it happened there. And they've kind of let it drain away over time. Well, other states can do what they want. They can pass new statutes, their constitutions are older than ours, etc. Our Constitution was written in 1890. So it's going to lock in what the people thought that they had as their law and what they considered to be their standard of due process at that time. And the only history we have is you've got a Supreme Court saying, you don't have that right. You've got a bunch of prosecutors, of all people, thinking that we do. And that's what you're looking at. The fact that the rest of the country is off doing other things, I don't think necessarily matters. What matters in terms of the courts has to read plain language of statute. The court has to consider the fact that, at the very least, California knew what it was up to, and that even if the people who wrote our Constitution didn't know what was going on, that doesn't mean that the people who wrote the Idaho Revised Statutes in 1887 didn't know what they were signing on for. And whether or not they were sitting at the Constitutional Convention isn't something that I put enough effort into to figure that one out, but I don't think it necessarily answers the question anymore. Anyway, I think the only other thing I wanted to touch on was how, by agreeing with me, the court is able to save the indictment by turning it into a presentment. As a presentment, there's a lot laxer evidentiary rules and everything else. Much of the complaints we would have about it essentially disappear, and the state has its presentment. And as far as I'm told, one of the reasons why we had a grand jury in this case is because in another case I had argued that if you don't do a grand jury, you can't have the death penalty, which I still believe. But if you have a presentment, that's also listed. And so the state still gets what it wants. And we get a preliminary hearing, which it seems to me would be worth the candle for us.
I think there was some instruction about present for the grand jury, was it not? They were given that option.
Well, I think they were told about it. So I don't know. And the court maybe can find it. I can't find a single presentment in the history of Idaho. So I don't know if they've really ever been used.
I don't know.
And I hadn't really even thought about what they are or what they meant until taking up this argument. But from what I could tell, going back to the field code and looking at everything else and the statutes that we have on hand, I mean, essentially it's like grand jury light. Typically, for the presentment, the idea for who is getting the presentment seems to come from the grand jury members themselves. They just come in with some information about somebody, they make an accusation like it's a complaint, and then it goes off and it gets treated more like a complaint than it does an indictment. I don't know if the court found anything otherwise, but that's the way that it appears to supposed to work. Like I said, I don't know if anybody's ever done one, but I do think that what the state accomplished in the indictment in this proceeding would easily meet the requirements for presentment. And I don't think we would have any real ability to argue with them. Because I mean, the grand jury itself can just come in and say, these are some facts I heard from my neighbor, and I think that guy committed a crime, and that's enough to start the wheels of justice. And I'm relatively certain we've met that requirement. And so if the court does that, then the state still has a piece of paper that says the death penalty can be sought in the Fifth Amendment of the United States Constitution. And a preliminary hearing would be offered to give us the ability to take a closer look at this case than what was given at the actual grand jury. So, you know, and everybody could win. I do have that as an option for the court. Does the court have any questions? It looks like you might.
I might on your reply.
Okay.
We'll see.
Thank you.
Thank you. And Mr. Nye?
Thank you, Your Honor. As much as I enjoy the frolic through legislative history, as a trial attorney, we usually have a shortcut. And that is we check to see if the Idaho Supreme Court has ruled on the issue. And in this case, it has multiple times. So in Edmondson, the Supreme Court said, and I quote, "The purpose of the grand jury proceeding is to determine whether sufficient probable cause exists to bind the defendant over for trial. The determination of guilt or innocence is saved for a later day. As long as the grand jury has received legally sufficient evidence, which in and of itself supports the finding of probable cause, it is not for an appellate court to set aside the indictment." This court is bound by that holding. The Idaho Supreme Court applied that holding in two subsequent cases, Martinez and Jones, both cited in my brief. The Court of Appeals has applied that holding repeatedly. This court is also bound by its holdings. The only other thing I would add is, to summarize Mr. Robinson's argument, Idaho law supports it as long as you ignore the Idaho Supreme Court California law supports it, as long as you ignore the California Supreme Court. Idaho's constitutional history supports it, as long as you ignore the founding fathers. I could go on, but there's nothing to see here. The Idaho Supreme Court has ruled on this, and this court is not right. Unless the court has any questions, I'll respond after my brief.
Thank you, Mr. Nye.
Thank you.
Okay, Mr. Logston, you want to add anything else?
Well, that's just not what happened. I mean, Judge, courts say things all the time. They call it dicta. When a court is listing off...
Sometimes we call it the law.
Sometimes. But what we're talking about when we talk about Edmondson is we're talking about dicta. I mean, nobody was arguing in that case that probable cause was the standard. They were arguing over whether or not it's fair that some people get a prelim and some people get a grand jury. That's what that argument was about. And the guy didn't come in and say, oh no, I got a grand jury and the standard is beyond a reasonable doubt, but that's too, I don't like that, I'd rather have a prelim with a probable cause standard. That doesn't occur in that case for various, I'm sure, fantastic reasons. And the same thing happens in these later cases. I mean, it gets responded to.
What a waste
And yeah, like I said, the Supreme Court adopted a rule, but it's never tested the constitutionality of its own rule. It's never heard arguments on any of these things. It's not stating a holding after an argument. What it's doing is it's just reviewing what it believes the law to be that nobody's picking a fight about. I'm picking a fight about it.
And you may have the opportunity to do that to the Supreme Court.
Well,
I mean, that's what you're building. That's what you're building for. Because you know that I am constrained by existing law. I can't just change the law as a trial court if it's established. And I would say that in Edmondson, there wasn't an argument because it was settled law. I mean, I think that's really the problem. So, of course, a lot happened from 1880, 1890 to now, but the law doesn't always just sit still. I mean, it evolves, and that may be just what happened naturally. I don't agree that the language of the statute is completely clear, too. I mean, I think you can interpret it different ways, and a lot of people have interpreted that language different ways. Whether it's beyond a reasonable doubt or a probable cause. And you can argue with me about that. I'm kind of baiting you about that. So,
Judge, the cases that say that are very self-serving. These are courts that are essentially openly hostile to the idea of using beyond reasonable doubt standard. And so they make claims like to warrant really means to permit the trial jury to see it. That's not the wording of this statute. The California case gets written in the backdrop of a statute being passed in the 1940s that says probable cause is what you're going to look at when you're deciding whether or not these indictments should stand. So it really doesn't, whether or not the grand jury is being told something else to some extent turns into a moot point. The reality is, just because the courts didn't like what the legislature had adopted, and in our case, unlike California, unlike New York, but what was part of the concept of due process in our Constitution was written. Just because the Supreme Court doesn't like it, doesn't mean it's somehow settled law because it refuses to follow it. It has to actually have a case and determine it. Now, occasionally, they can pass rules like they did, and so that's where this whole question of whether or not this is a substantive right and procedural right comes. But they never ruled on it. And Your Honor has the ability to look at the whole mess, the totality, and say, what is the law? What was the law in 1890? And when did it change? I don't think what the court can write is an opinion that says, well, we don't know when or how it changed, but by 1890, clearly the probable cause was the same in the state law. There has to be something where the Supreme Court considers these things in order for it to be settled law in a way that in which your Honor would be right and say, I can't do anything about it. They've never settled this question because nobody ever brought it up. Because it's really hard to get a copy of the field code in 1913. Well, I don't know. But
There was, I can't remember the name right at the moment, but in 1950s, it was dicta, where the judge, the appellate judge said, no, that's not the standard because they were using beyond a reasonable doubt in that case. Starts with a G. But anyway, there was a discussion in that case about what the standard of proof is or should be in the grand jury. So there have been touches of that along the way, I think, but you're right, there's not a whole lot of law until maybe Edmondson that was pretty clear. And then as Mr. Nye pointed out, a couple of decisions after that. We've got a case, which I think was 1987, something like that. So, yeah, I mean, I appreciate your argument. I mean, it's interesting. I'm constrained by the law, though. Back to that. You're making your record. That's good.
Judge, cabinet decision held some things. It's true, but nobody was arguing about that standard of proof. The fact that they state it while they're walking through what a grand jury is versus what a preliminary hearing is, that doesn't settle what the standard is. Just because they said it doesn't make it the law. I think their jurisdiction is limited, and yet broader than the United States Supreme Court, although if you read that most recent opinion where Judge Stegner doesn't agree with any of them about what their jurisdiction is like, it gets kind of complicated. But the point is, they can't just say in an opinion where nobody's arguing anything, oh, and by the way, the law of the land is this. Nobody briefed this issue in Edmondson. Nobody briefed it in any of the cases that came after it. They didn't set in stone via that opinion what the standard is. They tried by adopting the rule. The rule is the question. The court has to try to figure out, is it a procedural right or a substantive right? If the court says it's a procedural right, and essentially what the court is saying is that the courts get to decide how much it takes for one of us to be thrown in the lockup, put to death, etc. Which I can't find any case that has ever said that. They've all said that the standards being set by the Constitution or the legislature, setting these standards over and over and over again. So for the Idaho Supreme Court to issue a rule setting the standard of proof, even though there is a statute that says otherwise,
Jesus, Father God, Lord.
they can't do that. That didn't become something that, I mean, they did, but the court is in a position to consider whether or not they could do it. The court can tell the Idaho Supreme Court this rule isn't constitutional. Courts can do that. I mean, we consider bail issues, we consider bail on appeal, things like that, statute versus procedural rights. Those things occur, and the lower court can look at that like anybody else can. Who's in the right? Is it the legislature or is it the court? So I think the court can decide all these things. But if the court's going to say that you can't, I hope you'll at least write a 32-page order in which you explain how right I am about everything except that. Thank you.
I'll work on that. Thank you. I appreciate the argument. I think it's really creative. And I appreciate the journey back through history. I think it is an important factor in determining what the law is and why the law was established the way it was. But even you, okay, and I've heard this, but even in your brief, and this is your quote, okay, that the whole of modern jurisprudence on the issue is against it, as well as the least one founding father of this state. So I get it. I mean, what it comes down to me is that I am constrained by what I believe is settled law in Idaho. I may be wrong, but this is certainly an issue that you would have to bring up with a higher court, like the Idaho Supreme Court, and I look forward to getting that from your perspective settled in Idaho. We'll see. There's the rule, of course, which is we've talked about, but this argument really is fighting against some case law too. You may say that it's all dicta. I mean, that's debatable, I suppose. But the Idaho criminal rules, specifically Rule 6.5A, expressly states that probable cause is the standard, not beyond a reasonable doubt, and for a grand jury's indictment. And I think I have 3 or 4 recent, because this argument has been circulating in the state. I think I've had 3 or 4 district judge decisions denying the motion and the argument. So I am going to deny that argument. I think the argument is good, but I can't go that far. Not today. I'll give you a written decision. I can't guarantee it's going to be 32 pages. It might be longer. It might be shorter. So we'll see.
Listen.
But it's always
Guess what?
enjoyable to
Today.
have an argument with you, Mr. Logston. So I think that's all we have to do still. Ms. Taylor?
That's it for today, Your Honor.
Okay, and Mr. Thompson?
Yes, sir. We're done for today.
Okay, nothing else to address then. Okay, well, I hope you all got a touch of Idaho history and the law and how it works and our Idaho and United States Constitution. So go out and learn some more. Okay, thank you all. We're adjourned.
We got to watch that at the very end again. The judge is so sarcastic. It's awesome.
Recent, because this denying the motion and the argument. So I am going to deny that argument. I think the argument is good, but I can't go that far. Not today.
Not today.
I'll give you a written decision. I can't.
Not
guarantee it's gonna be 32
today.
pages. It might be longer. It might be shorter. So we'll see.
Look at the court reporters even
It's always,
smiling.
Enjoyable to have an argument with you, Mr. Logston. So
Watch Kohberger's face. Watch.
I think that's all we have to do still. Ms. Taylor?
That's it for today, Your Honor.
Okay, and Mr. Thompson?
Yes, sir. We're done for today.
Okay, nothing else to address then. Okay, well, I hope you all got a
touch of Idaho history and the law, and how it works, and our Idaho and United States Constitution. So go out and learn some more. Okay? Thank you all. We're adjourned.
Totally, totally, totally. Totally is poked fun at his defense. Oh, that was so funny. She's like, that's it for today. Oh my gosh, that was great. That was great. So, do we even have a next hearing date? Did they even say anything? I don't. All they had to do was this. I guess we wait for the next court date to be scheduled. Oh man, that was funny. That was funny. So they do have on other news. Let's go to the other news. They do have this dude's house surrounded. They're searching homes in his neighborhood. So I don't know. We will see. We will keep our eye on it. I am going to go relax. It's been a long day, and I'll see you guys in the morning. If anything happens with this manhunt and we need to cover that in the morning, we will do that, and then we will redo the Michael Vaughn. But as of now, we're going to be doing Michael Vaughn 10 a.m. Eastern Standard Time. And like Mandy Joe said, hit that like button, shit stains. Let's roll our credits. I'll see you guys in the morning.
I don't give a damn, I don't really care about you and your problems. I don't give a damn, you talk way too much. I have
Go into
heard
the clinker,
enough
the big house.
about you and your
Diarrhea on the
problems. I don't give a damn, I don't give a damn, damn, damn. I don't give a damn, damn, damn.
Listen. Guess what? I do today.
You wanna be with me. You wanna feel something real, but I'm feeling differently. You're making plans to get to France, but don't wanna face the fact that I ain't got time for that. Staying up late, sleeping all day, dreaming about Cadillacs.
Had a hard time hearing you. Do you mind pulling the microphone down and then aiming it up at your chin?
Thanks so much, Jennifer.
Hi, Jennifer.
I am here to help you learn.
Shut up, Amica.